Hello, we're going to begin with today's session. The topic is jurisdiction, and I am very honored to present tonight's lecturer. We have Oscar Felipe Merchan Garcia from Colombia, and also Maria Alejandra Franco from Colombia too. I will present Oscar, and he will present Maria Alejandra. So Oscar is he has an LLM candidate. It's a lawyer from Universidad de La Sabana, an LLM candidate from the same university. He participated in the Philip C. Jessup in the 2019 and 2020 editions, winning the Colombian National Rounds and runner-ups, respectively, awarded as Best Oralist of the Colombian National Rounds of the Philip C. Jessup in 2019 and Second Best Oralist in 2020. He has served as judge of several national rounds of the moot court, including Pakistan for preliminary semifinal rounds, Zambia preliminary and semifinal rounds, and Guatemala preliminary rounds. And I have to say that he was one of the toughest judges we've had. Currently, he serves as coach and advisor of the Universidad de La Sabana, so you will be free of his judging, but try to learn as much from him as possible today. Currently, as I said, he's coach and advisor of Universidad de La Sabana team for the Jessup, as well as he's also a professor of the International Law Department of the Faculty of Law and Political Science of La Sabana. He's former advisor of Human Trafficking and Academy in the International Organization of Migration. He has been junior associate of litigation and insolvency team of one of the top 5 ranked law firms in Colombia. He's advisor and research assistant for expert appointed before the Inter-American Court of Human Rights. He's advisor on civil, administrative, and public law in a major company of consultancy in Colombia. And currently he serves as legal advisor in the Honorable Congress of the Republic of Colombia. So welcome, Oscar, and thank you for being here. I will give the floor to you.
Thank you, Claudia, so much for your kind invitation, and great to meet you all. Here with me tonight is accompanying me, Maria Alejandra Franco. He is also an ex-participant of the Philip C. Jessup Moot Court competition. She represented La Sabana in 2020. She was one of the members of the team that were runner-up and classified to the international rounds in 2020. Unfortunately, that year, the international rounds were canceled due to the COVID-19 pandemic. And that was kind of our participation in the Jessup competition that year. She is an LLM candidate of Universidad de La Sabana in International Law. She is one of the best graduated topics of their generation. She serves with me in the LLM program. She is also an assistant in the Faculty of Law and Political Science of Universidad de La Sabana, and she's currently a corporate lawyer and a corporate attorney of one of the major companies in the beauty sector here in Colombia and in Latin America, which is called Belcorp, that you may be familiarized as is the owner of beauty marks such as Essica and Saison and others. So it's with great pleasure to introduce Maria Alejandra. She was my teammate in 2020. We have to live almost 1 year together. And the topic of this night is jurisdiction of the International Court of Justice. We want to focus directly with the International Court of Justice jurisdiction, as you may entertain disputes in the Philip C. Jessup under the framework of the Jessup under the framework of the International Court of Justice, sorry. So I'm going to share my screen and we have a brief presentation. Maria Alejandra will speak first about a preliminary issue that you should be really careful about. And this is the difference between admissibility and jurisdiction, because they are not the same. And in some cases, most of all, states tend to confuse challenging the jurisdiction of the court and challenging the admissibility of claims. And that has been one of the most common mistakes when litigating before the International Court of Justice. Maria Alejandra is quite an expert in this topic, as in the Jessup 2020, there was some major concern about whether a challenging was about the jurisdiction or whether it was about the admissibility of the claim itself. So I will share my screen now and we will proceed. Please let me know if you see my screen.
Yes.
Thank you. Okay, so in essence, we will discuss about the generalities of the jurisdiction of the International Court of Justice. The index that we manage for this session, which is going to be quite executive, is going to be a general advice regarding the moot court competition and the analysis of jurisdiction in itself, the preliminary question that I previously mentioned, the types of jurisdiction that englobes and encompasses the International Court of Justice as its function, the rules regarding the jurisdiction of the court in the UN Charter, in the Statute of the International Court of Justice, and a bonus that is quite problematic nowadays, which is the understanding of the forum prorogatum question. So, an analysis of the jurisdiction in the Philip C. Jessup. As a general advice, I will yield the floor to my colleague, Maria Alejandra Franco, she will give you a brief advice of how to understand jurisdiction and how to read the Jessup problem in terms of jurisdiction. Be careful, the 2023 Jessup competition case, despite that as of today doesn't present clearly a question regarding jurisdiction or admissibility, you must have in clarity, and you must be aware that the jurisdiction of the court in the Jessup problem encompasses certain extent. So be careful of reaching too far the jurisdiction of the court, even when in this particular case, there are not direct challenges of the jurisdiction of the court. So Maria Alejandra, the floor is all yours. And we will now begin with the question. What is jurisdiction? What is admissibility? And why that has been problematic in litigating before the International Court of Justice?
Thank you, Oscar. Thank you, everyone, for being here. I'm so honored to be part of this space and to share you like some of the previous knowledge that we got into the Jessup competition. And the like Oscar previously mentioned, the jurisdiction and admissibility problem was a really tough problem in the 2020 Jessup competition. First of all, you need to understand that there is not only a conceptual difference between jurisdiction and admissibility, it's also a practical difference between one another, and there is a practical relevance in order to litigate in front of the International Court of Justice regarding these two concepts. So jurisdiction, in a broad matter, is the power that the International Court of Justice have to know a specific problem. This power that the International Court of Justice has is given by the consent of the states. That's a really important part. Later, Oscar is going to give you like the specific tips of how a state can give jurisdiction to International Court of Justice. However, there is a difference between jurisdiction and admissibility because, as I previously said, the jurisdiction is the power that the court has. However, admissibility is regarding that if the court should or should not know the case, even if he has the power to know the case. So, for example, when a state already gave the jurisdiction or already told the court, you can deal with this case, but there is a legal matter, a legal question, a legal ground that the court must say, there is not here, even though I have the power to know the case, I, as a court, cannot attain the case because there is a legal ground that does not allow me to do this, that does not pertain to do this. For you to take into account, and if you, and even in this Jessup problem, or maybe later in your practice, need to know, there is the Article 79 of the Rules of the International Court of Justice that actually pertain this difference between jurisdiction and admissibility, because the Rule 79, and I quote, says that following to the submission of the application and after the president has met and consulted the parties, the court may decide if the circumstances warrant that the question concerning its jurisdiction or its admissibility, so there's here, even here in the rules in the court, the distinction between jurisdiction and admissibility of the application should be determined separately. So the ICJ has understand this also, the distinction, following that the objections to admissibility normally take the form of an assertion that even the court has the jurisdiction and the fact stated by the applicant are assumed to be correct, there is a reason the court should not proceed to examination. And normally I will give you some examples in which the court has says, okay, here I have the power to attain this case. However, because of this, I'm not going to resolve the grounds of this case. And it's the mootness of the dispute. If there is or there is not really a dispute between the parties, a legal dispute that the International Court of Justice can really solve, there's also the delay of the submission of the case is another reason that because of admissibility grounds, the court has not decided the grounds of a case. There is actually also another ground of admissibility in which the court has rejected to solve a case, and is the lack of indispensable third parties of the proceeding or the failure to exhaust local remedies. This particularly happens in the human rights cases where there are grounds where the rules said that previously to go to an international court of justice or an international tribunal, the parties need to exhaust local remedies or need to exhaust previously matters between the parties before going to international court of justice. So in the big picture, this is the importance of the distinction between jurisdiction and admissibility. This is also important because the court has a clear knowledge of what is jurisdiction and what is admissibility. And it's really important that as representative of the state before the International Court of Justice, you also know this difference. Because if you mistake them or if you can confuse them, the court will not allow that argument and it will not be beneficial for your team in the Jessup competition, or maybe in the future if you are agents before the International Court of Justice. So it's really important to have the basis and the knowledge and the distinction from jurisdiction argument or an admissibility argument. I will give you a really good example that we use in our Jessup competition in 2020. And it was that our main argument for the respondent part of the Jessup was about that the court, even the court has jurisdiction to know the matter because it was a matter pertaining trade of a plant. Even if the court has the power to know that specific matter because of an international treaty that was signed between the parties, ratified between the parties, there was a pending proceeding in the dispute settlement body of the WTO at the same time. And we were arguing that the least pendens doctrine was applicable in this case. And because of the least pendens doctrine, that was a ground, a legal ground in which the court could not attain this case because there was a risk in international law that there will be dissenting opinions between the WTO dispute settlement body and the International Court of Justice. It was a really tough argument, but it's a really good example of what an admissibility argument is, because the court can know about the case. The states gave consent to the International Court of Justice to know about this case. However, we were arguing that the least pendens doctrine was a legal ground in which the court couldn't know about this specific case. So that's the importance of this specific matter. And I now will leave the floor to Oscar to continue with the presentation.
Thank you, Maria Alejandra, so much. So in order to present you a brief about what Maria Alejandra told you, you must remember that the first step in order to analyze a dispute before the International Court of Justice is to determine whether the court has the power to entertain such a dispute. And then, if the parties creating and elaborating their arguments know or argue that there are some grounds in which the court should redress or refrain to pronounce, that will be the second step, which is admissibility grounds. A clear example comes even before the International Court of Justice existence, which is regarding the Permanent Court of International Justice in the case concerning certain rights of minors in Polish Upper Silesia, in which the Permanent Court of International Justice precisely makes the difference between having the power to understand a dispute and to analyze whether under the ground on litis pendentia or lis pendens, as Maria Alejandra was telling you, the court should pronounce or not, or to wait, or to even stop the proceeding and wait for the other proceeding that was pending before an arbitral tribunal. And why that is important? and why it's in a central core of the Latin American Jessup School. As you may see, jurisdiction is different because jurisdiction as the power of the court encompasses two forms. Pursuant the Charter of the United Nations and as well as the Statute of the International Court of Justice and some articles of the rules of the court, three different legal bodies and three different legal treatises in itself, which pertain to specific questions, one regarding the cooperation and assistance between the states members of the United Nations, the Statute of the Court, which is the central body of the understanding of proceedings before the International Court of Justice, and as well the rules of the court, which is the specificality of the procedures before the International Court of Justice. If you put them all together, you will find that the International Court of Justice has two types of jurisdiction, a contentious jurisdiction and an advisory one. And why are they different and why they are strong and why they exist even? The contentious jurisdiction is the normal jurisdiction that you may be familiarized, which is disputes between states as in accordance to Article 35 of the Statute of the Court. Whenever a state has a legal dispute or a different understanding of law with another state, then you will have a contentious case between the parties. But in some cases, there are certain entities, including international organizations associated with the United Nations, that may ask the court to resolve a general legal question. That is the advisory jurisdiction of the court. And that renders to the famous advisory opinions of the International Court of Justice. What is one of the major differences between contentious jurisdiction and advisory jurisdiction? The contentious jurisdiction is binding only upon parties. But if you look upon the statute of the International Court of Justice and the rules of the court, the decisions adopted under the framework of the advisory jurisdiction, that is the advisory opinions, are not binding at all. But the very same court considers that the ruling pertaining or presenting an advisory opinion is of a great significant character and of a great weight in international law. Major examples of how relevant the advisory jurisdiction of the International Court of Justice are precisely the advisory opinion regarding the independence of Kosovo, as well as the advisory opinion regarding the construction of a wall in the occupied Palestinian territories. If you look upon the final chapter of the advisory opinions of the court, you will never find words which give direct orders to specific states, but rather that answer legal questions. As for example, in the advisory opinion of the construction of a wall, the court concluded that the construction of the wall may and should be considered as a violation of human rights law in the context of the occupation of certain territories in Palestine made by Israel. So if you see, the court never told Israel to cease directly, but rather gives the recommendation, is an advisory opinion. So it's an advice that, wait, Israel, it's possible and it is quite clear that certain actions in which you engage while constructing the wall in occupied territories may be considered as violations of human rights law. But it never gave the order, as of a difference in contentious jurisdiction, in which the court orders remedies and methods of reparations whenever it considers that one state breached its international obligations. So in general, and for you to take to your houses and to your thinking process, the first step to understand the jurisdiction of the court is precisely that it's a twofold jurisdiction, the contentious one and the advisory one. So why is relevant for the Jessup competition to analyze the jurisdiction and in the context of the competition? Because you should be careful when reading any case, even beyond the Jessup problem, or even reading previous Jessup problems, you should understand and delimit specific questions about what is the basis of jurisdiction of your case, whether there are preliminary objections in the case, what is the extent of jurisdiction as to how far or how much the court can reach when analyzing specific subjects, the type of case, whether it is a special agreement or is a statement of agreed facts, and whether there are claims and counterclaims, because claims and counterclaims are of a specific relevance because they are subject to rules that are provided and presented in the Statute of the International Court of Justice, but more precisely in Article 80 of the Rules of the Court, which encompasses the requirements or the conditions in order for a counterclaim to be admissible before the International Court of Justice. Those requirements are one quite general, which is that the counterclaims falls within the jurisdiction of the court. And the second requirement is that the counterclaim is directly connected to the subject matter of the dispute. If you look upon the first requirement, which is whether the counterclaim falls within the jurisdiction of the court, you shall demonstrate that what you're arguing and counter-arguing falls within the scope of the jurisdiction that of the dispute that the court is trying to assess. So in generality, the rules of jurisdiction of the International Court of Justice are provided in the United Nations Charter, more precisely in the chapter 14, which contains Article 93.1, Article 93.2, and the advisory jurisdiction presented in Article 96. So there is a rule, which is the general rule of jurisdiction before the International Court of Justice, which is the ipso facto rule and the rule of entitlement. It is considered that whenever an state is member of the UN Charter and has ratified, and it is considered a state party of the United Nations Charter, it is ipso facto and therefore automatically member of the Statute of the International Court of Justice. Why is that relevant? Because if you look upon the Statute of the International Court of Justice, it is provided in Article 35.1 that the statute is open to all members of the United Nations. But there are other examples, which is the case of states which are not members of the United Nations, but desire to be party of the Statute of the International Court of Justice. One of the most significant and commonly the best example to analyze this issue pertaining Article 93.2 is the Resolution 91 of 1946, in which the Swiss Federal Republic, before joining the United Nations, that is Switzerland, decided to not be party of the United Nations at first, but only to the Statute of the International Court of Justice. Providing Resolution 91 of 1946, the Security Council was entitled to determine under which circumstances the government of Switzerland should be able to be party of the Statute of the International Court of Justice. And those requirements maintain in time. There are similar cases such as Japan, Finland, Nauru, and the island of Mauritius. And what are those requirements? The first one, provided in Resolution 91 of 1946, was precisely that if you are not party to the United Nations, but you want to be party of the Statute of the International Court of Justice, you accept the entirety of the rules provided in the Statute of the International Court of Justice as binding upon your state. The second requirement is quite interesting, which is that you accept the obligations provided in Article 94 of the United Nations Charter. What about Article 94? What is so of relevance, Article 94, and why the Security Council decided to provide that specific rule? Because if you look upon Article 94 of the United Nations Charter, you will find something quite interesting, which is Article 94.1 determines that the decisions of the International Court of Justice are binding upon the parties. And the second paragraph of Article 94 of the United Nations Charter provides the consequences of not fulfilling or complying with the decisions of the International Court of Justice. That is, that you may be referred to the Security Council of the United Nations, and that Security Council in its powers may determine the legal consequences of you for not fulfilling, such as economic sanctions and even interventions under the framework of the Chapter 7, and even authorizations or give a state's power to intervene using force whenever necessary if you do not fulfill with the decision adopted by the International Court of Justice. And the third requirement, as you know, is all about money. The court says that, and the Security Council says, that if you want to be party to the Statute of the International Court of Justice, not being a member of the United Nations, you should pay the International Court of Justice in equity. So as all the members of the United Nations, you should give money in order to support the expenses and the taxes that are given in the Netherlands in order to support the work of the International Court of Justice. And now moving to Article 96, contains the advisory jurisdiction of the International Court of Justice. You should be careful with this because not every person, not every state is entitled to request advisory opinions. If you look upon Article 96, it is clearly determined that only international organizations are entitled to request advisory opinions before the International Court of Justice. But that's not the only requirement. Such questions must be directly connected with the functions of that international organization. And let me give you one example. You may be familiarized with one of the most important advisory opinions of the International Court of Justice, which is the advisory opinion regarding the legality of the use or threat of use of force of nuclear weapons and using nuclear weapons in context of war. But previous to such an advisory opinion, there was an advisory opinion presented by the World Health Organization regarding the very same topic, which was the legality of using nuclear weapons. In the view of the court, such an advisory opinion was not proceeding because the determination of the legality of using nuclear weapons was not part of the functions of the World Health Organization. So it decided to not admit the question. So those are the requirements in order to present a legal question of general interpretation of law before the International Court of Justice, if you are an organization that wants to seek answers of the International Court of Justice. And now let's take upon a clear example of why is it relevant. The Palestine Declaration of July 2018 presents that pursuant the Security Council Resolution 91, which provides those rules that I previously mentioned, they decided to adopt and be party to the Statute of the International Court of Justice, even if they are not members of the United Nations. And such declaration encompasses certain limits, but in the case of Palestine, Palestine decided to make a wider declaration, that is a general declaration. And why is that relevant? Because as a state, you are entitled to make two types of declarations whenever you are trying to subject yourself in accordance to the Resolution 91 of 1946. And that is, you may address specific declarations in which you only recognize the jurisdiction of the International Court of Justice in a specific events and to a specific extent, or in the case of Palestine, in which you can make a broad declaration, accepting that whenever you're trying to solve a dispute concerning international law, you accept the jurisdiction and the compulsory ipso facto jurisdiction of the International Court of Justice. And therefore, accepting that you are binding and you are in somehow governed by the Statute of the International Court of Justice, as well as the provision of Article 94, which is, I must comply with the decisions adopted by the International Court of Justice, or I may be subject to the Security Council. So now let's move on to the Statute of the International Court of Justice. So Article 34 clearly says which or who is entitled or who has the capacity to appear before the International Court of Justice. And that's a tricky question because you may think it's quite obvious that it's only contentious jurisdiction between states, but be careful because there are cases before the International Court of Justice that pertains the protection of individuals. So what happens in such cases in which the state is arguing before a specific individual? I will talk about that later. But how is that relevant? Because in accordance to Article 34, the states are the entities which are empowered to appear before the International Court of Justice whenever they fulfill their requirements, submitting themselves to the jurisdiction, before the jurisdiction of the court. Now, Article 35 says that parties and non-parties to the Statute of the United Nations Charter may also appear before the International Court of Justice. One is the rule that I previously mentioned, which is provided in the United Nations Charter, which what happens in cases in which you want to be party of the Statute of the International Court of Justice, but not a party of the United Nations. And there are some cases in which you are not party to the statute and not party to the United Nations, but you want the court to address on this. So in accordance to paragraph 2 of Article 35 of the Statute of the International Court of Justice, in the event in which you are a state that is not party to the Statute of the International Court of Justice, and that doesn't have the interest of being party to the Statute of the International Court of Justice, and also you are not member, of course, of the United Nations, you may be allowed to appear before the International Court of Justice under certain conditions. That was the case of Japan before joining the United Nations. The International Court of Justice entrusts the Security Council once again to give certain recommendations as to whether this type of states, in which events they may be entitled to appeal the court. And the requirements are exactly the same as in resolution, the resolution of 1946, which are accepting that in the framework of the dispute, you are subject to the rules of the statute as well as the rules of the court. You accept the bindingness upon the decision, and you also accept that you must pay the fee in order to support the judges of the International Court of Justice. So what is the essential rule of jurisdiction of the International Court of Justice? It is clearly presented in Article 36. There are many forms to appear before the International Court of Justice. The most common ground is a special agreement. We are parties of the United Nations, we are parties of the statute, and we decided by mutual consent to present the dispute before the International Court of Justice. That's more common than you think, but not that common as instituting proceedings, which is in the most similar figure to civil law and common law countries, which pertains to denounce a state before the International Court of Justice. The term instituting proceedings against is a similar term to denouncing a state before the International Court of Justice. So the other ground of appearing before the International Court of Justice is clearly instituting proceedings or present an application against one state. And the other ground, which is not that common, but it happens, is the compulsory ipso facto rule of jurisdiction. Whenever you don't present a special agreement, or even you don't present a statement of agreed facts in which you institute proceedings, but rather what happens in the compulsory ipso facto jurisdiction. If you look upon Article 36, paragraph 2 and paragraph 3, it is provided that states may present declarations recognizing the jurisdiction of the court and present disputes before the court whenever another state presents the exact same declaration. And such declaration should render or should be encompassed in the framework of interpretation of treaties, legal disputes regarding the applicability of international law, and etc. So those are the grounds of appearing and the capacity of the states in order to appear before the International Court of Justice. Then you have one of the most interesting clauses, which is Article 37 of the Statute of the International Court of Justice, which is the Permanent Court of International Justice clause. What does this article say? As you may know, before the United Nations, the entity that encompasses the major regulations between relations among states prior to the Second World War was the League of Nations. And the Court of the League of Nations was the Permanent Court of International Justice. What happened? Many of the states present their declarations accepting the jurisdiction of the Permanent Court of International Justice, but they didn't even address the jurisdiction of the International Court of Justice. So in the statute, the major solution was, there is no problem. If both the states accept the jurisdiction of the Permanent Court of International Justice, it is automatically considered that such an acceptation should be rendered as equal as an acceptance of the jurisdiction of the International Court of Justice. But there are certain limits, which I'm going to present you later, specifically in the cases concerning the legality of use of force, which involved Yugoslavia against a lot of states, many other states, including Belgium, France, the United States of America. And then you have probably the most common article of the Statute of the International Court of Justice, which is the rules that the court may apply using that power of jurisdiction, which are what are the rules and the applicable sources by which the court is going to solve the dispute. You have treaties, international customary international law, principles, as well as in order to interpret and as an auxiliary sources, even so, decisions of other tribunals, their previous decisions, and the teachings of the most highly qualified publicists. So, as I told you, the jurisdictional issues are quite resumed and quite well presented and analyzed by the International Court of Justice in the cases pertaining the legality of use of force, which involves the government of Yugoslavia, the flag that you're seeing in the screen, and many other cases, and many other states. Essentially what happened, the government of Yugoslavia prior to the succession and becoming, and prior to the dissolution of the Socialist Federal Republic of Yugoslavia and originating the short Republic of Serbia and Montenegro, present and initiate proceedings against Belgium, France, the United States of America, alleging that they violate the rules of use of force by intervening in the conflict against Bosnian and the genocide of Muslim Bosnians. In the view of Yugoslavia, the court was entitled to address such disputes because they were different cases, but the court decided to analyze the 6 contentious cases in one judicial decision. So what happened? In April 1999, the Federal Republic of Yugoslavia filed in the registry of the court the applications. But nonetheless, and specifically the United States of America said, I don't think that the government of Yugoslavia could or is allowed to present this claim because in our view and in our perspective, the government of Serbia and Montenegro, which is the current state, was not part of the United Nations Charter at the moment in which the application was filed in the register of the court. So why is that relevant? Because the court, for the first time in history, analyzed in just one case questions of jurisdiction ratione persona, ratione materia, and ratione temporis. Ratione persona, whether in fact the states that are parties to the dispute accept the jurisdiction of the court. Ratione materia, as to whether the legal dispute was subject to the jurisdiction of the court, and ratione temporis, which was the major concern, as to whether in time of filing the application, the court was entitled to exercise the power of jurisdiction. And the court, in order to summarize this, dismissed every ground of jurisdiction and reject all of the claims presented by the governments of Serbia and Montenegro in one judicial case, and therefore accepted the arguments presented by the United States of America, the government of Belgium, in which they consider that at the moment in which the application was filed in 1999, the government of Serbia and Montenegro was not party to the United Nations Charter. And why is that relevant? And let's move on to the ratione persona issue. So ratione persona issue, analyzed under the framework of the International Court of Justice, was addressed under whether after the adoption of Resolution 55 of 1999, in which it was accepted that the government of Serbia and Montenegro to be party to the Statute of the International Court of Justice and party to the United Nations Charter, was therefore automatically part of the statute, and that despite filing the application of proceedings in 1999, and if considering that the resolution came 2 months, even approximately 1 year later, whether the retroactive effects could be applicable. And the court says in an answer in the negative, it is okay that you filed the application in 1999, but considering that you became party to the United Nations Charter in 2000, therefore you were not member of the United Nations. So the other ground in order to determine whether the court should be entitled to exercise the power of jurisdiction was analyzing the ratione materia issue, and is to determine whether the Article 35, paragraph 2 was applicable or not. And remember that Article 35, Paragraph 2 of the Statute of the International Court of Justice present the question as to whether what happens with the states which at the moment of filing the application are not party to the United Nations Charter. And the court says it doesn't fulfill the conditions of Resolution 9194 of 1946, which is that they accept the requirements to be party to the Statute of the International Court of Justice, that the government of Yugoslavia could be considered that accept the bindingness of the decision or the eventual decision, and that the government of Yugoslavia was quite reluctant in accepting paying the fee of the members of the International Court of Justice. In the view of the court, what happened? In accordance to the ratio in materia question, and as to determine whether a bilateral treaty signed between the government of Yugoslavia and these other states, including Belgium, United States, regarding cooperation, mutual assistance, and amity relations, as that clause that gives the power to the International Court of Justice to resolve disputes regarding the interpretation of the treaty should only be applicable whenever it's considered that the Statute of the International Court of Justice was enforced. And considering that such treaties were signed after the entry into force of the Statute of the International Court of Justice, Article 35, Paragraph 2 was not applicable. And there were certain doubts about whether the government of Yugoslavia was accepting or not the requirements of the Resolution 94. So then the court moved on to whether it has jurisdiction ratione temporis. And it considered that, as in the ratione persona analysis, as it was not a party at the moment of instituting proceedings, all the cases presented by Serbia and Montenegro should be dismissed. So you have 6 major institution of proceedings with the expenses and the payment of the fee of the lawyers, which were entirely dismissed under the ground of jurisdiction by the International Court of Justice. And that is why of paramount relevance, analyzing and being careful with determining the jurisdiction of the International Court of Justice. And remember this, under the principle of la compétence de la compétence, which implies the court is entitled to determine itself whether it has jurisdiction or not. It doesn't even care the arguments of the parties. It may consider the arguments, but the court is the one with the power to analyze whether it has jurisdiction or not. In the cases concerning the legality of use of force, the court dismissed both the arguments of the United States in its entirety, as well as the arguments of Yugoslavia, and created its own ruling asserting, I do believe that the United States has right in asserting that the government of Yugoslavia was not party to the United Nations Charter, but not for the reasons of the United States, but rather for the reasons I'm going to present to both parties. And that's why the court has a huge power when analyzing cases, because you can present preliminary objections, and the court may dismiss those objections under the grounds of jurisdiction based on the principle of the competence of la competence. So now let's move on to the last part, which is one of the most difficult questions in the International Court of Justice, which is the foreign prorogatum cases. So what happened whenever I, as a state, present an institution of proceedings, or I want to recourse to the International Court of Justice, and the other state, the respondent state, is not party of the statute or doesn't present any compulsory ipso facto declaration accepting the jurisdiction of the court. The court, since the Corfu Channel case, authorizes the states in as much as their powers and the state sovereignty to solve that question by their own. So the International Court of Justice have recognized and has recognized that the jurisdiction of the court at the time when applications are instituting, even when the states doesn't have the possibility to assert or even to explain the direct jurisdiction of the court, they may solve that issue by presenting declarations or by certain actions in which they accept that in fact the court has jurisdiction. As you see in the screen, the states have the possibility of subsequently accepting the jurisdiction of the court to entertain the case. The court therefore will have jurisdiction even if at the moment in which the application was instituted, there were questions regarding the jurisdiction. So in essence, as you may see, the jurisdiction of the International Court of Justice is essentially and entirely based upon consent of the states. If you don't have the consent of the states, jurisdiction cannot be argued. So let's take a brief look about the relevant decisions of the International Court of Justice that contribute to the elaboration and creation of the foreign prorogatum principle. The Corfu Channel case, which implies the dispute between the United Kingdom and Northern Ireland as a third party against Albania, present the liberty of forms rule and the unilateral withdrawal rule. So in the view of the International Court of Justice, as in the first case even enacted by the court, it was considered that the jurisdiction of the court was entirely based upon a letter draft and sent by the registrar of the court of the government of Albania. The government of Albania at the moment of the institution of proceedings in the Corfu Channel case was not accepting the jurisdiction in an express manner. But when the United Kingdom decided to file the application against Albania, the government of Albania, in a simple letter without any type of formality, says something like, I accept and I will present myself to the court. So that's the liberty of forms. You don't have to fulfill any requirement if it is clear that your unequivocal decision is to accept the jurisdiction of the court. And there is another rule, and that is that whenever you present such type of declarations accepting the jurisdiction of the court, you cannot unilaterally withdraw them. That is, for example, if the government of Albania decided to address that letter before the registrar of the court, and that it regrets of accepting the jurisdiction of the court, it's not entitled to unilaterally withdraw, because the first act in the time was accepting the jurisdiction of the court. And the court, by such act, accepts and acknowledges that it has the jurisdiction to entertain that dispute. Then you have one of the most important cases in the terms of foreign prerogatum, which is the Haya de la Torre case before the International Court of Justice, which involves a dispute between the government of Colombia and Peru of many diplomatic questions that even was think to be solved by preliminary objections. But what happens was that the court, in enacting and using the power, create one of the most important rules in terms of foreign prerogatum, which is the tacit acceptance. So you don't need, to express in a clear or even direct manner your consent if your actions as a state or the entities that may render the capacity of the state or may be empowered to speak as the voice of the state may lead to the conclusion that you are unequivocally accepting the jurisdiction of the court. So in the case of Albania, you have a letter, but in the case of Haya de la Torre, there was no letter, no any type of document accepting the jurisdiction of the court, but rather just the mere presentation of the government of Peru in the institution of proceedings. So the court considered that if you are presenting yourself and accept that I have jurisdiction over the merits, therefore you are accepting that I have jurisdiction at all. But be careful, because then we have the Anglo-Iranian oil company case, which is the United Kingdom against the government of Iran. Nor any type of action may be considered as a unequivocally and direct declaration of acceptance the jurisdiction of the court. What happened in such case? The government of Iran decided to participate in the proceedings, but the participation of the government of Iran was directly connected to the arguments of such government to challenge the jurisdiction of the court. So the court considered that even if the government of Iran decided to present in the Netherlands, the presentation was only to challenge the jurisdiction, and therefore the mere participation was not considered to be the equivocal indication, the non-equivocal indication that the government of Iran was accepting the jurisdiction of the court. So you have to be careful. You may appear before the International Court of Justice, but that doesn't imply that you are accepting that the court has jurisdiction to entertain a dispute. Your actions, as in the Haya de la Torre case, must be directly rendered as that you are unequivocally accepting that the court may solve the substance of the matter. And the most important case regarding foreign prerogatum is one of my favorite cases, I must say, is the certain questions of mutual assistance in criminal matters, which faces the government of Djibouti against the government of France. So you have in the slide, the picture of Bernard Borrell. The entirety of the case concerns this individual, but it was not about the protection of this individual. Sadly, this individual was dead at the moment of the institution of proceedings. What happened is that this was a major and important person of the government of France, serving as a diplomatic correspondence person and as an agent of the government of France in Djibouti after the separation of Djibouti of France. He died in lands of Djibouti, and the government of France initiated criminal proceedings against certain Djibouti nationals. What happened in such case? The government of Djibouti, under the Convention of Mutual Assistance in Criminal Matters, requests the government of France the file or the expedient or in somehow the brief or the summary of the case concerning the investigation and the criminal proceedings in France of the assassination and the death under extreme and rare circumstances of Bernard Borrell. And the government of France denied surrendering the brief or the file of the case, arguing that there was one exception under the Convention of Criminal Assistance, which was the protection of state sovereignty or even the protection of security. And it was considered by the government of France that if surrendering the file to the government of Djibouti, that will lead to a possible non-judgment and the violation of France of prosecuting, investigating, and sanction the violations against the life of Bernard Borrell. Why is this case about foreign prerogative, you may ask? So Article 38.5 of the rules of the court says, in essence, that, as I told you before, you may be party to the proceedings of one case only if, in accordance to Article 38, it is unequivocally accepted that such a state is accepting the jurisdiction of the court. But what happened? In accordance to Article 38 of the rules of the court, such a recognition is limited and to the extent as to which the declaration is made. And why was that relevant? Because in accordance to the government of France, first of all, decided to present a letter before the International Court of Justice, the registrar of the court, accepting the jurisdiction of the court. But if you look at screen, it was only valid for the purposes of the cases in accordance to Article 38, paragraph 2 and paragraph 1, in respect to the dispute subject to the applicability, and the time is strictly within the moment in which the institution was filed. And why was that relevant? And why that concerns foreign prerogative? Because the declaration of acceptance of the government of France, despite being explicit, was limited, and was limited in only to the claims as and how the case was presented at the moment of institution of proceedings. And why is that relevant? You may have cases before the International Court of Justice in which you have the legal grounds and the factual basis, but in passing time, you discover something new facts, new legal grounds, but most of all, new facts. You discover new events that surround the circumstances of your case. The question is, at the moment that I institute proceedings, those cases didn't exist or were not part of my knowledge. Is the court entitled to accept those facts or to put those facts or those new issues in the analysis of the case or analyze the case before the court? In the view of the court, in its general decisions that do not concern foreign prerogative, you have to prove the connexity or the connection between those facts and the legal grounds of your dispute. So for example, let's assume that we have two states, and those states engage in an international armed conflict, or even if not, those states are having questions of the use of force. And you have a specific evidence at the moment of instituting proceedings that the state B is actually violating the rules of the United Nations Charter, the Geneva Conventions, the International Covenant on Civil and Political Rights. But then in the coursing of the proceedings, you discover new evidence. How can the court accept that new evidence? In the view of the court, especially in the Bosnian genocide case, the court considered that if you can prove that that new fact, that new evidence is connected or is of significant relevance in order to analyze the dispute, and as much, those evidence, those new facts are valid. But in the view of the court, that rule is only applicable if you are not under the framework of a forum prorogatum recognition of the jurisdiction of the court. What happened in the Djibouti against France case? After the investigation and the question regarding the files of Bernard Borrell, new facts arise as to the detention of an interrogation of nationals of Djibouti that were involved or have the knowledge to be part, or that have the knowledge, to the circumstances surrounding the death of this person, and the case concerning X and the assassination of Bernard Borrell by the actions of a person which was protected by its identity and for public research and public sources. So in the view of the court and for public purposes, in the view of the court, as the government of France decided to limit the jurisdiction and the recognition of the jurisdiction as to what was presented in the application, and considering that these new testimonies, this new interrogation process come after the declaration of France and the declaration of the government of Djibouti and the institution of proceedings, those declarations should be dismissed, was the argument of France. And in the view of the court, as in accordance to Article 38 and paragraph 5 more directly of the rules of the court, and as well as the foreign prerogative rules that were developed before, the government of France therefore was right. I cannot accept, whenever the jurisdiction of the court is under the basis of foreign prerogative, new evidence if the declaration under the foreign prerogative limits its time to the moment in which the institution of proceedings was met or presented. So those facts regarding interrogation testimonies of the nationals of Djibouti that were of significant relevance in order to solve the question of the criminal mutual assistance between Djibouti and France were dismissed by the International Court of Justice because the recognition of the government of France pertaining the jurisdiction of the court didn't empower the court to accept that new evidence. So that's in essence the foreign prerogative problem. The major case is in fact therefore the certain questions of criminal assistance in mutual assistance in criminal matters, because the court accepted the applicability, the express applicability of foreign prerogative as a basis of the jurisdiction of the court. And it considers that in fact its jurisdiction was under Article 38 of the rules of the court. So that will be all for this session. I hope you have deeper knowledge regarding the jurisdiction and why jurisdiction is relevant. I hope you understand why it's relevant when analyzing cases, not only for the Jessup competition, but in general when you're reading the case law of the International Court of Justice. Because my advice in general is that you may answer a case and even you may win a case without entering in the substance of it. If you can challenge the jurisdiction of the tribunal, if you can challenge the jurisdiction of the court which is entitled to know the case, then you don't have to exhaust yourself in solving the substance of the matter. And that doesn't only apply for the International Court of Justice. As litigators and as lawyers and attorneys in your country, you should always look upon in your cases, whenever you're analyzing a case, the question of whether the court has jurisdiction to solve it. Because if not, your first argument should be, wait a second, you're not entitled to solve this dispute. And that will give you amounts of points in your law firm, in your professional career, because you do not exhaust analyzing the substance of the matter, but rather determine whether in process and in the formality, the case should be accepted or not in the tribunal. So in the International Court of Justice, as you may see in the decisions, the vast majority of states try always to challenge the jurisdiction of the court, because if you enter to the substance of the matter, it will be quite problematic for your state, the possible determinations of the International Court of Justice. So always try to challenge the jurisdiction, and if not, the admissibility of any type of proceedings. And if not, try to fight as best as you can in the substance of the matter and in the merits of the case. So that's why jurisdiction in the International Court of Justice is so important. Be and bear that in mind in order to succeed in your professional career. And thank you for your time. Thank you, Claudia, once again for the invitation. I hope that this session was enlightening and enriching for the students. And I hope you guys enjoy. Thank you so much for your time.
Thank you, Oscar. Thank you also to Maria Alejandra. And thank you for this wonderful presentation and all the knowledge that I'm sure we got after this session. I just want to ask if there are any questions.
I know that it's quite late, so
and late and early because we have some teams from Pakistan and India, so they are
that's
in
amazing.
I really admire that they are here because it's like, I don't know, if 4 or 5 a.m. in the morning for them. So thank you very much.
I remember when I was judging in Pakistan and in Colombia was like 3 a.m. in the morning, and they were like in middle afternoon. That was rough. So thank you for your patience, the students of Pakistan and India.
And also Iraq. Yeah,
and
I've
Iraq,
also
amazing,
judged some rounds from the region at my 2 a.m. or something, and it's really, really fun.
It's really fun. And I forgot to say, for the ones who are participating in Jessup 2023, the best of luck and success. And I hope that you succeed in your national and, if possible, in the international rounds as well. And let's hope to see you in DC this following year. I hope that my team made it, of course. But
let's hope. If not, come anyways. You can. If not, you can come as judge. So
yes.
So,
thank you so much, Claudia. Maria Alejandra has to leave because she have a meeting in their company, but she was really, really thankful and appreciate this time. For the ones participating in Jessup 2023, she's going to be a judge. So,
so beware.
You maybe counter her.
Thank you, Oscar, and thank you. Please thank Maria Alejandra also, and we will see you on Monday.
We will see you Monday. Thank you.
Thank you.
Good night, good evening, good
morning
for everyone.
Bye. Thank you.
Bye.